It is time to check in with our CJAD 800 legal contributor, Chris Dimakos, who is on the line right now. And Chris, I'm going to start with a story that I was not all that much aware of. So Elon Musk, as we all know, took over Twitter, turned it to X, and did some strange things I remember back in the time, but I did not know this. He sent an email to employees then telling them if they wanted to stay on with the company, they needed to click a link that said, yes, I'm on board. And if they didn't, they just get a parting package and be let go. So as it turns out, in your note, one high-level employee decided not to click the button, not to accept the package, and he said he couldn't make a decision until he knew exactly what the package entailed. Well, he was terminated, and he sued, and he scored a $600,000 settlement. So let's take that and put it in, sort of our boundaries here. Someone gets something from a company they're working for, especially, I guess, if it's a new company taking over, but could it apply anyway, where you're told you have to decide by telling us yes or no right now, you staying on board or no? How would it work?
Right, and it's important for people who are listening right now to know that many companies over the last couple of years, ever since COVID took place and there was a mass hiring trying to fill people up with remote work, some of the companies had some remorse. And what they wanted to do was they kind of wanted to force employees' hand by saying, well, here's how your job's going to be going forward. It's not going to be like it was. Here's how it's going to be going forward. It's going to be really difficult. There's going to be a lot more hours. There's going to be a lot more responsibilities. So if you're okay with that, let us know that you accept. And if you don't, that's fine. We're going to let you go and we're going to give you a package. Almost like forcing people out the door. And by showing them how their job is going to change. So this is a trend that many companies have started to use, and Twitter is no different. They did the same thing, sent it all to employees, and said, click yes if you agree to this new work environment, and if you don't, we'll package you out. So what does that mean for us? It just means that as an employee, there are rules and laws in place that protect you when you try to be forcibly played in this way, right? So in terms of delays, in terms of your job security, the employer cannot just terminate you because you don't agree to changes that are going to come into place. And although they might put forth a package that they think is suitable, that doesn't necessarily mean that it is. And I can probably bet that it's not, right? So especially if it's done on a mass scale, they're going to want to try and mitigate how much that's going to cost them. So the lesson here is it might be intimidating, but it doesn't mean that you're making concession that of all the job security that you've garnered over the years. It's important to know that. So don't rush anything. This employee played it perfectly. He didn't accept. He wanted to get advice, and he filed a complaint and got what was he was entitled to, and probably a little more.
So in this case, this seems to me kind of the same idea. And just if I can kind of extend this a little bit, say, you had that meeting with HR, they tell you, okay, sorry, your job's done. They hand you that piece of paper and try to, I think a lot of times, intimidate you into signing it right there and then. And the advice always has been, do not sign it, walk away, take a look at it, or get someone to take a look at it before you actually make a decision. The same would apply here.
Right. And it's the same also, the delay is such an important one because sometimes companies decide, hey, let's give them till tomorrow to sign. And that will basically pressure them. And if they don't have enough time to think about it and to get consulted, well, then we'll we'll twist the screws and try to really get them to agree to something in a rush. And that doesn't work. It's been time and time again frowned upon by the courts. So if you don't have enough time to consider what's being offered to you, then it doesn't mean anything in terms of if you decide not to sign it right there. It doesn't mean that you're not able to go and get it later or file a complaint for it. So don't be rushed. And more companies now with HR departments that understand how it works, they're actually telling you that you have to sign a paper saying that you've been advised by a lawyer. So when you're signing on something, they want you to acknowledge that you've had the time to see a lawyer so that we don't have problems later on. So it's a tactic that less and less companies are using, these rush tactics. But remember, you have rights and job security that is cannot be conceded because the company wants to act quickly. You have those; they're yours, and you have to play this strategically and use what laws you have in your favor to your advantage. You don't want to concede that stuff. Like for example, signing in a 24-hour delay. That's not something you want to do. You want to have time to contemplate this and look at all the different options that are available to you.
So I'm thinking, in the case of someone, because this Twitter situation is a new owner moving over to take a company, right? And deciding
Right.
to run the things the way he wanted to run them. Does it matter if ownership has changed, or it doesn't matter at all?
It doesn't matter at all in terms of your rights as an employee. Ownership of the company, it doesn't mean anything because the company is its own legal person, and your relationship is with the company, not with the owner. So this employee's relationship and the laws that protect his job are with Twitter, not with Elon Musk. Elon Musk became the shareholder and took over the company, but it doesn't mean anything in terms of losing or conceding or sacrificing your job rights. It's kind of like someone who has a lease, a business, and the owner of the building changes. The lease is still there. It's still a valid lease, and you can continue to operate at that building. But the main thing I would tell people here is companies sometimes try to force changes to your job, and those changes are so far away from what you've been hired for that it's almost like a new job in itself. And when that happens, when that line moves so far toward one way, well, then that's when the law says it's almost like you're being fired from your job because it doesn't exist anymore. So it's very, very important when you are in that position and you get an email like this, you want to sit down with a professional and get advised. What are all my options here? If I say yes, if I say no, how long is it going to take to complain in a tribunal? What's it going to cost me? How do I finance my life during that time? All of these things have to be discussed.
Last question. Talking again about a new owner for a company, right? You see a lot of times when that happens, then they start to consolidate, and all of a sudden they'll drop 200 jobs all at once, right? So it's not have you accepting anything or not. Now, obviously, if that's the case, you will get a package, right? But can you get more than that?
Right. Yes, you could. And the way, they usually do it so under the guise of economic conditions. So they say, we're not firing you because of you. The company has no choice but to fire all these people because we have to let them go. We need to be able to stay volatile and be able to operate. But when they work out these packages, they usually do so by giving you not the maximum amount that you'd be entitled to, but they usually do so, 80% or 75%, just enough so that you're dissuaded from going to file a complaint and pay a lawyer and do all of these things. They usually try to price you at a point where you say, is it really worth it for me to go after that extra 20 or 25, given how long it's going to take and what it's going to cost? So the answer to that question, obviously, case-by-case basis, you have to review the package, but they usually come in a little lower than what you would get in a court, and that's because it's immediate, it's there, and you're guaranteed. There's always a risk involved by going to court, but you're guaranteed whatever they're offering you. So there's no question they use that to make sure they do so at a lower price.
So just as a last point, these things start to happen, as you're saying, more and more often now. Typically when someone does walk away and decide, you know what, I am going to challenge this, I am going to seek professional help. Do they win? Do they lose? Is that a fair question?
You know what? The ones that do very well are the ones that had time to explore all the options. And again, it's not just about winning the case, because many people focus on, am I right or am I wrong? That's one of the main reasons why all things break down. The marriages, who's right, who's wrong, they want the admission. If you can just say to yourself, okay, that's one aspect of this case, but what about me personally? What's it going to be like for me over the next year? How am I going to finance my life if I don't have this package now? How am I going to pay for a lawyer? How's that going to work?
Right.
So you don't just look at the legal, you can win in principle, but you might end up being a loser afterwards because it costs you way more than you thought it would, and you have to take on a whole bunch of debt during that time. So my advice is it's not only about the case. You have to look at how it pertains to you and how your life is going to be during that process. You have to take all that into consideration.
Good advice as always. Chris Dimakos. Chris, thanks so much.
Thanks, Aaron.